Hello and welcome to the Law Lab. Here, we dissect and unpack everything legal. My name is Jacqueline Fuaopoku, and today we will continue our discussion on misrepresentation by bringing misrepresentation as a vitiating factor to a contract to an end. In our previous videos, we have discussed what misrepresentation is. We looked at certain statements that the court will not deem as misrepresentation, and also we looked at the three types of misrep or misrepresentation. Today, we'll be looking at the remedies that are available to the party that has been misled, and also the counterclaim or defenses of misrepresentation. We will first start with the remedies available to a party when he or she has been able to prove that he was misled into entering a contract. The first remedy to be looked at is the remedy of rescission. Mind you, the remedies we'll be talking about will be equitable remedies. The first remedy, as I've already stated, is rescission. What is rescission? Rescission is the right a party has to cancel or set aside a contract, either because he or she was misrepresented to or other reasons. The court has this discretion to grant the remedy of rescission. Mind you, in equitable remedies, it is at the discretion of the court, meaning it is not a right, but rather a discretion or a remedy that the court will grant to you. So the remedy of rescission is not necessarily going to be granted by a party, but most times, once you are able to prove and convince the court will grant you the remedy of rescission. As I have already stated, the remedy of rescission means you are setting aside the contract. And for the court to allow you to set aside a contract, there has to be the possibility of restitution. The Latin word is restitutio in integrum, meaning there has to be a possibility of restitution. Restitution simply means to restore. So if you cannot restore the property for which you obtained under the contract, then you cannot rescind the contract. I will state it again. The general rule is that for rescission to be granted, there has to be the possibility of restitution. And I have stated that rescission is you setting aside the contract. So setting aside the contract, it means the court is allowing you to cancel the contract and put you in the position that you were in before you entered the contract. So if you had a laptop and you sold the laptop but you realize you sold it to a fraud person, then if you want to rescind the contract, there has to be the existence of the laptop. Meaning, if the laptop is not in existence, it's hardly the court will grant you the remedy of rescission. For example, Amma and Kofi have entered into a contract, and the contract was sale of goods of the contract was for Amma to sell to Kofi oranges. But later on, Amma sold to Kofi and realized that Kofi is a fraudster, but then she had sold her oranges already. For Amma to go to the court and set aside this contract, the court has to be satisfied or convinced that the existence of the oranges can be proven. Meaning, if you cannot prove the existence of the oranges, then Amma cannot set aside the contract. As I have already stated, the party seeking to rely on the remedy of rescission must show there is a possibility of either returning or recovering the property that was obtained under the contract. But there are certain situations where a party can decide to leave the jurisdiction in which the contract was entered into in order for the other party to notify him or her about his intention of rescinding the contract. This is called abscondment. As I've already stated, if the other party absconds and he's unable to notify the other party on their decision to rescind the contract, the court will tell the party that if you are able to show us the reasonable grounds for which or reasonable circumstances for which you tried to notify the person, but you were unable to notify the person because he has absconded from the jurisdiction, the court will still entitle the other party to rescind the contract. This was held in the case of Car and Universal Finance versus Cardwell. So in that case, the court illustrated that if you are able to show that you've tried on countless occasions to notify the other party about your decision to rescind and it has been proven futile, then the court will allow you to rescind without notifying the other party. The second exception I have already stated in the first exception is the remedy of restitution. Restitution means to restore. In order to restore you, there has to be the property, or the property has to be in existence, as I already stated in the remedy of rescission. So if there is no possibility of restitution, or there is no possibility of restoring you back, of restoring you to the position you were in through the property that was obtained under the contract, then the party cannot claim to rescind the contract. Anyways, this is under common law. Under equity, it has stated that rescission need not to be precise. It has to be substantial. Therefore, maybe you may have part of the property still in existence, then you can provide it to the court and the court will allow you to rescind the contract. But if the character of the property that was obtained under the contract has been altered in such a way that you cannot even recognize that property, then the remedy of rescission or restitution will not be available for you. I'll give an example. In a matter or in a situation where B sold a goat to A and A has already slaughtered the goat and has already cooked it, prepared pepper soup, you cannot recover the goat because it has already become, the subject matter has already changed its character because now it is in the soup of which the other party may or may not have already consumed it. Therefore, the remedy of restitution will not be granted to the party relying on the misrepresentation. These are the two remedies I'll be discussing with you. As I already stated at the beginning of the video, we'll be looking at the remedies and also defenses of misrepresentation. Since we are done with the remedies of misrepresentation, we will delve into the defense to misrepresentation. In every situation or in every legal argument, there are most times that a party may have done something but will tell the court that, yes, I agree, I have done it, but there was a reason as to why I did it. This is known as defense to an action. When the other party do accept that they misrepresented or they gave false statement, they will still tell the court that, yes, I have given false statement, but then this party cannot institute misrepresentation action against me because of certain circumstances. The first circumstance is lapse of time. Lapse of time is a bar to an action of misrepresentation. In all contract matters or in all contractual activities, time is of essence. That means once time begins to run and you do not institute the action and the time comes to an end, you have no right to institute the action. That means limitation has caught up with you through lapse of time. Lapse of time can occur in different forms. For example, you got to know about the fraudulent misrepresentation. Instead of you to follow up, you didn't follow up until the last minute and you decided that you are coming to court for the court to grant you the remedy of rescission or restitution or damages. The first thing, as I have already stated, is that the court asks you, has your right of action accrued? And if it is, why didn't you bring it to court on time? If you are unable to give reasonable reasons as to why you made the lapse of time catch up with you, then the remedy you seek to enforce or you seek from the court will not be granted to you. For innocent misrepresentation, lapse of time is a bar to rescind the contract, whilst in fraudulent misrepresentation, lapse of time usually is not a bar to rescission, but it can be an evidence of affirmation. Meaning, in fraudulent misrepresentation, until you have discovered that there was a fraud activity in the contract you entered into, the time will not begin to run. In simple terms, in fraudulent misrepresentation, time begins to run once you have discovered that there was fraudulent activities and you did nothing to rectify these fraudulent activity or to bring it to court and to rescind the contract. In the case of Leaf versus International Galleries, the court held that in innocent misrepresentation, lapse of time is a bar to rescission. In this case, the plaintiff decided to purchase a painting thinking that the painting was made by or was done by one constable. Unknown to both the plaintiff and the defendant, it was not the constable they had in mind. Therefore, it was an innocent misrepresentation. The plaintiff did not take reasonable steps to rescind the contract and waited until 5 years to rescind the contract. The court held that there was a lapse of time, and in innocent representation, lapse of time is a bar to rescission of a contract. The next defense to misrepresentation is affirmation. Affirmation means to accept something or to accept the outcome of an activity or of an action. When misrepresentation occurs and the other party comes to know about the misrepresentation, be it fraudulent, negligent, or innocent, the other party becomes aware that, the facts that they told me are false, or the facts that I relied on, they have turned out to be a misrepresented fact, but then I would still go ahead and perform my obligation because although they were misrepresented facts, I still accept the contract or I adopt the contract as mine. Once you adopt a misrepresented contract to be yours, or once you agree that let's go ahead, although I'm aware of the misrepresentation, then the court will tell you that, already you have accepted it, so we cannot do or we cannot extend our helping hand to you. This constitutes affirmation of a contract and it acts as a bar to misrepresentation or instituting an action of misrepresentation. Our last defense to misrepresentation is third-party rights. Third-party rights is a defense to misrepresentation. Misrepresentation is between the two parties, party A and party B. So once party C enters into the contract or gains an interest in the subject matter, then party A cannot rescind or cannot tell the court that, there was misrepresentation, therefore grant me a remedy, because the right of a third party has set in. For example, there may be a contract between A and B, and in that contract, B sold, let's say, chocolate to A. And when B sold the chocolate to A went to sell this same chocolate to C. And B realized that the chocolate he sold to A was because A represented certain facts that turned out to be false, and therefore he's coming back for his chocolate. The court will tell you that you cannot recover the chocolate because party C has now obtained the chocolate. But for party C to obtain the chocolate or for the third party right to act as a bar to misrepresent the action of misrepresentation, party C should have entered into the contract in good faith and should have paid value or consideration for the contract. Once these elements are proven, then party B will not be entitled to any remedy at all because the right of third party has set in. So far, in this video, we have discussed the remedies of misrepresentation and the defense to an action of misrepresentation. This brings us to the end of misrepresentation as a vitiating factor in contract law. Thank you for joining our journey in the discussion of misrepresentation. I urge you once again to like, subscribe, share, and comment. And if you have any question, leave it in the comment section. We will turn to you. Thank you and have a nice day.